This week, the House voted on several foreign policy measures. The House also considered legislation to impose sanctions related to forced organ harvesting, intellectual property theft, and impeding Georgia's Euro-Atlantic integration, along with permanently extending U.S. sanctions on Iran. Meanwhile, the Senate reviewed a joint resolution for congressional disapproval of a Biden Environmental Protection Agency rule on emissions from tire manufacturing and continued with nomination votes. President Trump's skinny budget. President Trump proposed slashing federal spending in his fiscal 2026 budget request, seeking to codify his administration's efforts to shrink the size of government. The request calls on Congress to reduce non-defense discretionary spending by 17% through an array of cuts to most agencies and by eliminating dozens of programs. Although delivered several months behind schedule, as is typical with new administrations, the proposal also calls for a 13% increase in national security spending, portions of which would be enacted through the Republicans' tax-focused reconciliation package. The House Armed Services, Homeland Security, and Judiciary panels approved portions of the bill to boost funding for military, border security, and other needs. The request, which will not become law but signals the administration's priorities, marks the first step in the appropriations process for FY26, which begins October 1st. Appropriators heard from administration officials this week ahead of drafting and debating annual funding bills. House and Senate Republican appropriations leaders are taking different approaches for the FY26 appropriations bills. Chair Tom Cole, Republican Oklahoma, stated that the House will consider its bills in line with the president's budget, supporting increased defense spending and shifting some domestic spending toward defense. However, the president's proposed requests call for flat funding for defense in the appropriation bill, with an additional $119 billion in defense spending included in the budget reconciliation package, totaling $1 trillion for defense, a historic high. Meanwhile, non-defense funding would be cut by nearly 23%, excluding extra border security and immigration enforcement funds derived through reconciliation. This approach is not sitting well with Democrats and centrist Republicans, including Senate Appropriations Chair Susan Collins, Republican Maine. Collins mentioned she has yet to discuss a top-line number with Ranking Member Patty Murray, Democrat Washington, but expressed concern about the non-defense cuts proposed by President Trump, describing them as extremely difficult to absorb, and highlighting the impact on areas like medical research. FCA International opposes limits to deduct state and local taxes, SALT, paid. FCA International joined the Center for a Free Economy in a letter to congressional leadership to oppose any limits on the ability of businesses to deduct state and local taxes, SALT, paid unless offset dollar for dollar by new and permanent pro-growth tax reforms. The ability of businesses to deduct state and local taxes paid on their profits is a long-standing, ordinary, and necessary expense embedded in the U.S. tax code. Corporations have been able to deduct state corporate income tax paid for as long as such taxes have existed. Pass-through entities like Subchapter S companies, partnerships, etc., were confirmed in their ability to deduct state and local profit taxes paid at the entity level in the 2017 Tax Cuts and Jobs Act. Businesses have always been able to deduct all other state and local taxes, such as property taxes and severance/extraction taxes. Business taxes paid on business profits are fundamentally different from the individual SALT cap debate. Businesses deduct costs incurred for all ordinary and necessary expense, rent, salaries, equipment, and state and local taxes. This has nothing to do with how much personal income tax, sales tax, and property tax an individual or family gets to deduct on their tax return. The two issues are only loosely connected because income taxes on businesses are apportioned based on where transactions take place, not where businesses are located. It's vitally important that all the provisions of the 2017 Tax Cuts and Jobs Act be made permanent. FCA International looks forward to working with the congressional leadership in the coming weeks to enact permanent, pro-growth tax reforms for American families and employers. DOL's guidance on how to determine employee or independent contractor status. The U.S. Department of Labor's Wage and Hour Division issued a field assistance bulletin providing guidance on determining employee or independent contractor status under the Fair Labor Standards Act. As the department reviews the 2024 final rule on employee or independent contractor classification, which is being challenged in federal court, agency investigators are instructed not to apply the 2024 rule's analysis in current enforcement matters. Instead, the division will rely on long-standing principles, further informed by classification in the context of virtual marketplace platforms. This approach offers greater clarity for businesses and workers navigating modern work arrangements, while legal and regulatory questions are resolved. The guidance does not change existing regulations, but reflects how the department is allocating enforcement resources during the review of the 2024 rule. It supersedes any prior or conflicting guidance provided to Wage and Hour Division staff on enforcement related to independent contractor misclassification. The department may still exercise enforcement authority in individual cases deemed appropriate by the Wage and Hour Administrator or a designee. For additional guidance beyond the Field Assistance Bulletin, workers and employers can contact the Wage and Hour Division at its toll-free helpline 866 for U.S. WAGE 487-9243.